A sizable legal showdown is taking shape at the top tier of America's judiciary, questioning the federal regulations on short-barreled rifles under the National Firearms Act. The Supreme Court has been asked to consider whether these long-standing rules infringe upon the constitutional rights of firearm owners. With the recent passing of what's being called the Big Beautiful Bill, which effectively cuts the federal tax on suppressors and short-barreled rifles to $0, this case has gained fresh urgency and national importance. The case goes by the name United States v. Robinson. It takes direct aim at the heart of the National Firearms Act, focusing on its regulation of rifles with barrels shorter than 16 inches. Mr. Robinson, the petitioner, has formally requested that the Supreme Court hear his argument, claiming these regulations violate rights safeguarded by the Second Amendment. His legal team contends that owning a short-barreled rifle shouldn't involve registrations, paperwork, or government permissions. It's essential to highlight that this isn't the first review of the case. The 11th Circuit Court of Appeals has already ruled to uphold the NFA's provisions on short-barreled rifles, maintaining that they are constitutional even following the Supreme Court's Bruen decision. That prior ruling stated the NFA's framework was aligned with historical tradition, despite the expanding Second Amendment protections affirmed by Bruen. But Robinson and his attorneys firmly disagree and are now asking the Supreme Court to overturn the lower court's decision and essentially do away with the NFA's short-barreled rifle stipulations once and for all. What adds another layer to this dispute is its timing. Not long ago, Congress enacted legislation, heavily favored by pro-gun lawmakers and signed into law by President Trump, that reduces the federal tax on NFA-regulated items like suppressors and short-barreled rifles from $200 down to $0. This new policy is set to begin in January next year. While it doesn't completely repeal the NFA, it dismantles one of its main enforcement methods, tax enforcement. This new law results in a curious contradiction. The government doesn't collect money anymore for SBR registrations, yet it still insists on registration and federal supervision. That is exactly what Robinson's legal team is focusing on. Their argument is that if the tax is gone, then the legal reason for federal regulation weakens considerably. From a constitutional angle, the case challenges whether the NFA's short-barreled rifle laws can stand when they no longer serve any distinct public safety purpose and when they enforce severe penalties for ownership that arguably shouldn't need government endorsement at all. The plaintiffs essentially say, if these rifles are commonly owned, if the tax is $0, and if there's no evident threat in owning one, why are they still being regulated like, contraband? This lawsuit isn't merely a technical legal matter. It might completely change the discussion surrounding the National Firearms Act. If successful, it could remove the federal registration requirements for short-barreled rifles altogether. That means no forms, no lengthy waits, no federal sign-offs, just the right to own a rifle with a 12-inch barrel, a stabilizing brace, or a folding stock without clashing with old federal mandates. Make no mistake, this case goes way beyond one individual's rifle. It's a test of whether the NFA, initially enacted in 1934, still stands valid under the current interpretation of the Second Amendment. With the Supreme Court's recent rulings heavily leaning toward individual gun rights, many believe Robinson might just make history. We'll closely monitor how this story develops. If the Supreme Court chooses to hear the case, and especially if it rules in Robinson's favor, it could reshape how Americans view short-barreled firearms. It could also open the door for more challenges against other parts of the NFA, such as those that govern suppressors or even automatic firearms. Let's examine what led to this case, as the facts hold as much weight as the legal arguments. On the morning of September 9, 2022, law enforcement in a Florida county received a tip about a suspicious vehicle parked on the roadside. When deputies arrived, they found a man, Mr. Robinson, asleep at the wheel. Through the driver's side window, officers noticed what seemed to be the buttstock of a rifle lying next to him. Using a flashlight, they woke him and instructed him to place his hands on the steering wheel. Instead of doing so, Mr. Robinson made the quick decision to drive off. A brief pursuit followed with officers turning on their lights and chasing him. Not long after, Robinson halted the vehicle and was taken into custody without further incident. A subsequent search of the car uncovered a loaded short-barreled rifle along with a separate 16-inch AR-style upper receiver. After being read his Miranda rights, Robinson admitted he'd recently bought the firearm in the Tampa Bay area. A check of the National Firearms Registration and Transfer Record, the official federal registry for items regulated under the National Firearms Act, confirmed the rifle hadn't been registered to him. That was enough for federal authorities to charge him under the NFA's laws regarding unlawful possession of an unregistered short-barreled rifle. He ultimately faced trial in district court with a bench trial, meaning no jury was present and the judge declared him guilty. The sentence delivered was relatively lenient by federal terms, 18 months of probation, including 6 months of home confinement. But Robinson didn't stop there. He took the matter to the 11th Circuit Court of Appeals, challenging his conviction on constitutional grounds. His appeal centered on two major points. Firstly, he claimed that prosecuting someone for possessing an unregistered short-barreled rifle violates the Second Amendment, particularly following the Supreme Court's landmark ruling in New York State Rifle and Pistol Association v. Bruen. Secondly, he argued that the National Firearms Act imposes an unconstitutional tax on the exercise of a fundamental constitutional right. The 11th Circuit, however, was unimpressed. Addressing the Second Amendment claim, the court heavily leaned on the precedent set in United States v. Miller, a case decided back in 1939. In that decision, the Supreme Court had ruled that short-barreled shotguns could be restricted under federal law because they were deemed dangerous and unusual weapons not in common civilian use. The 11th Circuit extended that reasoning to short-barreled rifles, stating no significant legal difference was seen between a shotgun with a barrel under 18 inches and a rifle with a barrel under 16 inches. Until the Supreme Court itself revises or overturns Miller, the lower courts said their hands were tied. As for the taxation argument, the 11th Circuit dismissed it entirely, suggesting that Bruen didn't invalidate all forms of regulatory fees or restrictions. According to their interpretation, as long as the regulation serves a general purpose, like requiring training or licensing, it could still be deemed constitutional under the Second Amendment framework. They saw the NFA's registration requirement as aligning with that category. Now the 11th Circuit ruling is being challenged directly. Mr. Robinson has submitted a formal petition requesting the Supreme Court to review his conviction and weigh in on two critical constitutional questions. First, whether the federal government's criminal penalties for simply possessing an unregistered short-barreled rifle breach the Second Amendment. Second, whether the National Firearms Act's requirements, which include taxes and registration, constitute an unconstitutional burden on the lawful ownership of commonly owned firearms. This case is now set to become a defining moment for gun rights in America. If the Supreme Court agrees to hear it, it could either uphold the NFA's authority or dismantle a significant portion of its legal basis. Either way, the consequences for firearm owners, especially those who build or own short-barrel platforms, could be substantial. Whether you're someone using a suppressed .22 long rifle, a homeowner defending with a compact 5.56 build, or a collector with NFA items in your safe, this case might directly influence what you're allowed to own and how you can acquire it legally. Another major issue highlighted in Mr. Robinson's petition is whether the criminal penalty for possessing an unregistered short-barreled rifle oversteps what Congress is permitted to do under its taxing authority, as outlined in Article 1, Section 8, Clause 1 of the Constitution, and whether it also infringes the 10th Amendment by encroaching on powers meant to stay with the states. Robinson directly challenges the lower court's interpretation of the Supreme Court's old Miller decision. According to him, the 11th Circuit overly relied on United States v. Miller without acknowledging its limitations. He argues that Miller never genuinely declared that short-barreled shotguns, or by extension short-barreled rifles, are not protected by the Second Amendment. Instead, the court back then chose not to assume that short-barreled shotguns were protected due to a lack of evidence. The defendants in Miller didn't even show up to make their argument, so the court wasn't provided any substantial basis to assess whether those firearms were in common use for lawful intentions. Robinson stresses that there's a significant difference between the court opting not to rule that a weapon is protected and the court decisively stating it is not. In his opinion, Miller should merely be seen as saying that the National Firearms Act can apply to arms that are not protected under the Constitution. It doesn't resolve the question of whether commonly owned, constitutionally protected arms like short-barreled rifles can be taxed and restricted similarly. Building on the Supreme Court's recent decision in Bruen, Robinson contends that the Second Amendment clearly protects short-barreled rifles. Because of that, he posits the government must bear the burden of proof and demonstrate that this sort of tax and registration approach is backed by a historical tradition of regulation. And that's a test, he argues, the government fails miserably. Robinson notes that the historical laws the government cites, those from the colonial and founding periods, were nothing like the NFA. Those initial laws aimed to ensure the populace was armed and ready, not to burden them with taxes or bureaucratic obstacles. None of them required individuals to register their firearms before owning them, and certainly none imposed federal taxes just for having a certain barrel length. Considering these points, Robinson is now appealing to the Supreme Court to take up the case and abolish the NFA's restrictions on short-barreled rifles altogether. And this is all converging at a very intriguing time. As most of you are already aware, Congress recently approved and President Trump endorsed a law that lowers the tax on NFA items like suppressors and short-barreled rifles from $200 down to $0. That change is poised to take effect early next year. The removal of the tax introduces a new wrinkle, raising a question. If there's no revenue being collected anymore, is the entire legal rationale for this restriction on even shakier ground? This is now the second significant challenge to the National Firearms Act's regulation of short-barreled rifles seeking Supreme Court review. It's worth noting that the court has recently declined several notable gun rights cases, including challenges to so-called assault weapons bans and magazine restrictions, so there's no guarantee this case will be heard. That being said, the unique mix of factors here, including the complete eradication of the tax, might create precisely the sort of legal puzzle that captures the court's attention. Whether they are prepared to resolve it now is yet to be determined. We'll keep tracking this story as it unfolds. If you found this overview helpful and wish to support the channel, it really helps when you hit that like button, leave a comment, or subscribe. Those small actions signal to the algorithm that this is content worth sharing, which helps us reach more people who are interested in liberty and the Constitution. And as always, thank you for being here. Remember, this country wasn't just built by armed citizens. It was built by armed scholars. And if we hope to preserve what makes America exceptional, it'll be the armed scholars who carry that torch forward.